experienced Connecticut LGBTQ divorce lawyer. When facing the complexities of divorce within the LGBTQ community in Connecticut, it's essential to have legal representation that understands the unique challenges and nuances involved. At the McConnell Family Law Group, we hold a steadfast commitment to upholding the rights and furthering the best interests of LGBTQ couples facing divorce. Our experienced Connecticut LGBTQ divorce lawyers recognize the unique challenges and legal nuances that LGBTQ individuals and couples encounter during this critical life transition. With unwavering dedication, we stand as advocates for equality, fairness, and justice, ensuring that your rights are protected, and your future is safeguarded throughout the divorce process. Your well-being and peace of mind are our top priorities, and we are here to provide the strong, compassionate representation you deserve. Top-rated Connecticut divorce lawyers for the LGBT community. LGBTQ divorce cases often come with distinctive challenges that require a lawyer with a deep understanding of both Connecticut divorce laws and LGBTQ-specific issues. Recognition of same-sex marriages. While same-sex marriage has been legal nationwide since the U.S. Supreme Court's landmark decision in Obergefell v. Hodges, Connecticut has recognized same-sex marriages since 2008. This history of recognition can affect certain aspects of divorce proceedings. Parental rights. LGBTQ couples may have unique parental arrangements, such as adoption, surrogacy, or co-parenting agreements. Ensuring the protection of parental rights is paramount in LGBTQ divorces. Non-binary and gender identity issues. Connecticut has progressive laws regarding gender identity and non-binary gender markers. Addressing gender identity concerns and name changes during a divorce requires a lawyer well-versed in these legal matters. Privacy concerns. LGBTQ individuals may have concerns about privacy and discretion throughout the divorce process, especially in cases where disclosure of sexual orientation or gender identity could have repercussions. Legal grounds for divorce in Connecticut. In Connecticut, divorce can be pursued on both no-fault and fault-based grounds. Understanding these grounds is essential when considering divorce, including LGBTQ divorce cases. No-fault divorce in Connecticut. Connecticut allows couples to file for a no-fault divorce, which means that neither party needs to prove that the other is at fault for the marriage's breakdown. Instead, the primary reason cited for a no-fault divorce in Connecticut is the irretrievable breakdown of the marriage. This means that the marriage has broken down to the extent that reconciliation is not possible, and there is no hope of the parties getting back together. Most, if not all, divorces currently filed in Connecticut are no-fault divorces. Fault-based divorce in Connecticut. Fault-based divorce in Connecticut allows couples to seek a divorce based on specific grounds or reasons that indicate that one spouse is at fault for the breakdown of the marriage. In a fault-based divorce, one party alleges that the other spouse's actions or behavior have caused the marriage to deteriorate beyond repair. Fault-based divorces can be pursued when certain conditions are met. Grounds for fault-based divorce include adultery, fraudulent contract, willful desertion for 1 year, abandonment, cruelty, imprisonment, drug or alcohol abuse. LGBTQ divorce process in Connecticut. The divorce process in Connecticut, including LGBTQ divorces, involves several essential steps. Filing for divorce in Connecticut, whether for LGBTQ couples or others, follows a specific set of procedures. Residency requirement. Before filing for divorce, the following residency requirements must be met. Either spouse must have lived in Connecticut for at least 12 months before filing. Either spouse lived in Connecticut at the time of the marriage, moved away, and then returned to the state to establish permanent residence. The marriage broke down irretrievably after the spouses moved to Connecticut. Grounds for divorce. Filing the complaint. Serving the complaint. Response. It is also important to note that a divorce may be filed before either spouse has had 12 months of residency in the state. However, the final divorce decree would only be granted after the 12 months residency requirement has been satisfied. Documentation required. Gathering and producing the necessary documentation is a crucial step in the divorce process in Connecticut. You will typically need to provide financial documents, property documentation, child custody and support information, spousal support information, equitable distribution in Connecticut. Connecticut follows the principle of equitable distribution when it comes to property division in divorce. This means the court will aim to divide marital property fairly, though not equally. The court considers various factors, including the length of the marriage, each spouse's financial contributions, and the parties' future financial needs. Child custody and support. Connecticut law recognizes the parental rights of LGBTQ individuals just as it does for heterosexual couples. The state is committed to ensuring equal treatment in custody matters regardless of a parent's sexual orientation or gender identity. LGBTQ parents have the right to seek custody or visitation rights for their children, advocate for the best interests of their children during custody disputes, be treated fairly and without discrimination in custody proceedings. When determining child custody and support in LGBTQ divorces, Connecticut courts prioritize the best interests of the child. Factors considered include child's preferences, parental roles, stability and well-being, financial circumstances, spousal support in LGBTQ divorces. In Connecticut, LGBTQ individuals have the same rights to seek spousal support, alimony, as any other divorcing couple. Alimony may be awarded to one spouse to ensure financial stability after divorce, especially if there is a significant income disparity between the parties. When calculating alimony payments in Connecticut, the court considers various factors, including the length of the marriage, each spouse's financial needs and resources, the standard of living established during the marriage, the age, health, and employability of each spouse, any child custody arrangements, LGBTQ-specific issues in divorce. Divorce can present unique challenges for LGBTQ couples in Connecticut. This section explores two essential aspects of LGBTQ divorce: adoption and parental rights, as well as the importance of LGBTQ-specific prenuptial agreements. Parental rights in LGBTQ divorces. Traditionally, state laws have included a paternity presumption that assumes a man married to the mother of a child born during the marriage is the child's father. Following the Supreme Court's decisions in Obergefell and Pavon, some states' courts have ruled that this presumption also applies to the wife of a mother who has a child through assisted reproduction during their marriage. Here's how the presumption of parentage works in the context of LGBTQ parental rights in Connecticut. Marriage presumption. Connecticut, like many other states, traditionally recognized a marriage presumption. This means that if a child is born to a woman during her marriage, her spouse, whether male or female, is presumed to be the child's legal parent. This presumption extends to LGBTQ couples who are legally married. Assisted reproduction. The Parentage Act in Connecticut explicitly addresses assisted reproduction. It recognizes that LGBTQ couples may use assisted reproductive technologies, such as sperm or egg donation and surrogacy, to have children. Under the Act, the presumption of parentage can still apply to the non-biological or non-genetic parent in a same-sex marriage if the child is born during the marriage. Acknowledgement of parentage. Connecticut allows for the voluntary acknowledgement of parentage. This means that if both spouses in a same-sex marriage intend to be the legal parents of a child conceived through assisted reproduction, they can jointly acknowledge their parentage, providing additional legal protection for their rights. Legal process. In cases where the presumption of parentage is challenged or when there are complex circumstances, Connecticut courts may become involved to determine parental rights. Courts will consider the best interests of the child and the intentions of the parties involved. LGBTQ prenuptial agreements. LGBTQ couples, like any other married couple, have the option to create prenuptial agreements. These legally binding contracts can serve several purposes. Protecting LGBTQ rights in divorce. In Connecticut, as in many other jurisdictions, protecting the rights of LGBTQ individuals during the divorce process is of utmost importance. This section delves into two critical aspects: understanding LGBTQ anti-discrimination laws and ensuring privacy and confidentiality. LGBTQ anti-discrimination laws. LGBTQ individuals have the right to fair treatment throughout the divorce process, ensuring they are free from discrimination or bias rooted in their sexual orientation or gender identity. This fundamental principle underscores the importance of equitable treatment for all parties involved. Ensuring fair treatment during divorce. When going through a divorce as an LGBTQ individual in Connecticut, it is essential to work with legal professionals who are well versed in LGBTQ rights and anti-discrimination laws. This ensures that you receive fair and equitable treatment throughout the divorce process, from the initial filing to the final judgment. Safeguarding LGBTQ client information. During divorce proceedings, some LGBTQ individuals may decide to reveal their sexual orientation or gender identity. In such cases, legal professionals must be sensitive to this disclosure. They should take proactive measures to safeguard this personal information, ensuring it remains confidential and shielded from unnecessary exposure that might lead to discrimination or harm. Contact us today at 203-541-5520 to schedule a consultation and take the first step towards a better tomorrow.